Welcome to Solutions Rising. I'm Rachel Branch, and joining me for this program is attorney Joseph Zlatnik, and I am delighted to welcome him. We are going to talk about our criminal justice system and perhaps clarify many points of why everyone in the United States is entitled to legal counsel and what the rule of law means for victims as well as those charged with crimes. Welcome, Attorney Zlatnik. Joe, if I may.
Please, thank you. Rachel, it's great to be here.
I'm so delighted that you're here. Plus, I really think it's important that we discuss. I don't think a lot of people realize that everybody is entitled to legal counsel. But I'd like you to start off and talk about whatever you would like about your background and your experience. And I might share a little side note that I really wish they'd take the word criminal out of the criminal justice system and just call it the justice system. Maybe that would change the accent.
Well, that's definitely something as a goal for us to have in mind. I mean, the idea is that everybody should have access to justice. We call it the criminal justice system, but in a way that you're absolutely right, it accents it. The way that people approach it is that a person involved in court is a criminal. That's not really the case. There's people from all walks of life that end up court involved. And so I agree with you. I think the justice system is what I would prefer to call it as well.
Oh,
yep.
Oh, I'm glad we agree on that.
Yep.
So will you tell us a little bit about your background? And something that surprised me is where you were born.
Right. I was actually born in Kiev, Ukraine. At the time, it was the USSR. So I moved to the United States in 1989. I grew up in New York City, went throughout the outer boroughs. I went to Bronx High School of Science for high school. Then I went to the John Jay College of Criminal Justice for my undergrad degree, which is kind of what got me started on this career in the justice system. And ended up going to Boston University School of Law for law school. There I took part in the criminal defense clinic, which was another huge part in how I got involved with this system. And then immediately out of law school, I started working here at the Berkshire DA's office, where I worked for about 2 years. And I left the DA's office to go into private practice and have been employed with Hochberg Law Offices in Pittsfield, Massachusetts for about the last 10 years, primarily as a criminal defense attorney. And
you said you had a criminal clinic, a criminal.
Right. So
is that what you called it? A criminal?
Yeah. So at Boston University, one of the wonderful resources that they have available is a criminal defense clinic. It's a one-year program where instead of participating in classes and learning the traditional way, you actually go to court. You actually represent clients, first as a junior lawyer and then as a senior attorney. It was teams of two. And the idea is that we would do everything that a defense attorney does, but before even graduating law school. So it was a great introduction to the system for me.
Well, you'll probably be surprised to know that I managed the tax and the civil clinics at the University of Bridgeport School of Law for low and middle income people. And it is a wonderful way to have law students get into the actual work supervised by an attorney. It's like a heads up before you even begin practicing.
Well, for me, there's a lot of ways of looking at the practice of law, but the way I've always seen it is it's kind of like an artisan profession. Traditionally, if you look back on the history of the way people practice law, it was like a guild. Older folks would teach younger folks, and it was a tradition that was carried on throughout generations. You can only learn so much from a book.
Yes.
And so clinical education is absolutely crucial to understanding what it's actually like to be in a court advocating on behalf of another person's rights in front of a judge. There's nothing quite like it. There's no way to learn that other than by doing.
Yes, and I think that's in a lot of professions, practicing is quite different from what you're learning in theory and in books, practice, and it needs the hands-on experience. So here we go. In the United States, everyone, and we mean everyone, is entitled to legal counsel. And I think a lot of people might have the misunderstanding that, okay, somebody's arrested and then they're guilty, and then we're innocent until proven not guilty. So would you speak to that, please?
So there's some complexity to that. First of all, when you say everyone is entitled to legal counsel, what we're specifically talking about here are if you are charged with a crime, then essentially one of your rights is your right to an attorney. This is a right that's been developed over the years through cases like Gideon versus Wainwright, where one of the questions is, how does one go about affording an attorney? Just because you have the right to something doesn't mean that you automatically get that thing, right? And so obviously legal representation can be very costly, particularly for people who don't make a great deal of money. And so the United States, throughout the United States, I can only speak to Massachusetts, but throughout the United States, there are programs that provide public counsel, court-appointed counsel to people who are charged with crimes. Sometimes free of charge, sometimes by charging them a much lower fee. But the idea is that the government has to assist poor folks with obtaining counsel. That said, the other point where this is important to understand is that the police cannot prevent you from talking to an attorney. So in many countries in the world, the situation is that if you are accused of a crime, you may or may not have access to a lawyer. Whereas in the United States, if the police want to interview you or interrogate you or investigate you, they have to allow you to have an attorney present when they speak with you.
Yes, and again, forwarding, and you're talking about in criminal cases. In civil cases, you're not necessarily provided. You're not.
So,
but there are the programs for that also.
There are programs for that. The other thing is that civil cases, there is a huge disparity in what kind of civil cases exist. So your prototypical case, civil case in the district court or the superior court, prototypically, you are entitled to have an attorney there to represent you, but of course you have to, pay out of pocket to hire that lawyer. But there are hearings in front of various, for example, at the RMV, where your initial hearing with the RMV officer may or may not be with an attorney. So your rights are different depending on the venue where you have your hearing.
Well, let's talk about verdicts. And when we're talking about verdicts in civil cases and verdicts in criminal cases, in a criminal case, it's a reasonable doubt, and in a civil case, preponderance of the evidence. Would you talk about that, please, and explain that?
So the American justice system is principally based on the idea that we would rather let 10 guilty people go free than have one innocent person lose their freedom over something that they didn't do. And so there are a lot of protections for people that are charged with crimes that don't necessarily exist in the civil system. Now, what do I mean by the civil system? The civil system is one in which there are two parties, and those two parties typically are on somewhat equal footing. It might be a person against another person, or a person against a business, or business against another business. The criminal system is one where the power of the government comes in and accuses someone of committing a crime, of breaking the law. And one of the things that is available to the government as a corrective is to hold people in jail or to take their freedom from them. That's not one of the things that happens in the civil system. Typically, in the civil system, no one is imprisoned. And so this is the impetus for what I'm about to say. If the government wants to imprison someone, make that person a criminal, someone whose freedom is taken from them, they are required to produce proof beyond a reasonable doubt that the person did in fact commit the crime. But in the civil system, because the stakes are, although oftentimes very high financially, but at least freedom is not in play, in the civil system, the burden of proof is preponderance of the evidence, which basically means, is it more likely than not? Now, the judges have a specific way of talking about proof beyond a reasonable doubt. Proof beyond a reasonable doubt is kind of a nebulous concept. It's not necessarily proof beyond any possible doubt, because in all human affairs, there's always going to be some kind of doubt. What proof beyond a reasonable doubt means is that the juror who's examining the facts has to have a moral certainty, a complete moral certainty that the person that is accused has actually committed the crime. And the other safeguard that we have in our system is the jury system itself. Because in the district court, you'll have 6 people who have to unanimously decide whether the person is proven guilty beyond a reasonable doubt. And in the superior court, it's 12 people who have to unanimously decide. So this is the idea, is that if the government wants to take your freedom, they have to convince 6 or 12 people beyond a reasonable doubt that you did the thing that they claim is a criminal act.
Obviously, we've just been through, and it's going to be ongoing, I believe, the horrible COVID pandemic, where people were incarcerated, and we're supposed to have rights to a speedy trial. What happens in that circumstance? And this is a very difficult situation, because people who are incarcerated, especially if they've committed heinous, violent crimes, you want protection of the public, but you also want their rights protected. How's that handled?
Well, the first thing to consider is this. Sometimes people ask, defense attorneys, like, how do you represent people that are charged with these heinous, horrible crimes? The first thing to understand is that no one walks into my office with a stamp on their head that says, I'm a guilty criminal. That's not how this happens. People are accused by the police. Sometimes people are accused by other people. So if you and I have some animosity towards one another, all I have to do is I have to make an accusation, either to the police or the court, that you committed this crime. Once I've made that accusation, assuming that it's credible, somewhat credible, a court will make a determination of probable cause, which is enough to open the case against you. Now, at that stage of the process, you haven't gotten your trial yet. They haven't proven the case against you beyond a reasonable doubt. The evidence oftentimes hasn't been provided to you. All that exists is this accusation. And in Massachusetts, there's a procedure, it's called a dangerousness hearing. And a dangerousness hearing is a type of hearing where if the Commonwealth can convince a judge that you are a dangerous person, they can hold you in jail for somewhere between 120 days in the district court and 180 days in the superior court. Now, when you think about that, in the superior court, 180 days, that's half a year. So, you can spend 6 months in jail without having even the barest evidence produced to you, other than just a basic police report and accusation. Without having a right to face your accuser, to cross-examine them, without having the right to have other people look at the case. It's just the judge makes a determination that you're dangerous, and off you go to jail. And COVID is where the system really fell apart. Because typically, the way we deal with that situation as defense lawyers is if your client is held on dangerousness for those 180 days, let's say, what that does is that says to me as a defense lawyer, I have to have this trial as soon as possible. This person has a right to a speedy trial, and I'm going to move this thing along to make sure that I get them out an opportunity to be in front of a jury within 180 days. But during COVID, the jury trials were suspended for a very long period of time. I don't have the exact dates, because what happened was essentially the court would close down for 6-7 months in a row, and then it would reopen for a month or two, and then it would close back down. So there was an extended period of time where people were held on dangerousness but had no right to a jury trial because there were no jury trials. And some people were held for a year or longer without the right to a trial.
It's quite frightening for somebody who's innocent.
It's absolutely terrifying. And, I had many conversations with clients. Obviously, I can't disclose the specifics of my client conversations. But I had many conversations with clients and clients' families where they would say to me, Joe, I didn't do this thing. There's no evidence that I did this thing. I have a defense. I was with other people when this thing happened, but I can't present this defense because there's no opportunity to present it to a jury, And so it's been interesting. As the courts have reopened, you've seen, so courts reopened in a big way roughly around February. We've seen from the Superior Court a variety of different results. We've seen some folks be found guilty, some folks be found acquitted, which means they were found not guilty, and some intermediate results like hung juries or split verdicts. But the point is, the people that were found not guilty, these were people who either were in jail or were out on some kind of bail conditions for years before getting a right to a trial. And these are people that were found not guilty at the end of the day.
Is there any compensation for people who are found not guilty and put in that position?
Typically, no.
Which is also another flaw because their livelihood is thrown away, their lives are damaged.
Right.
Of course, that comes to the Innocence Project, which is also a program that has found a lot of people who were incarcerated without proper evidence.
So the Innocence Project is a great program that
Yes.
absolutely does help people, but typically the Innocence Project gets involved after there's been a finding of guilt.
Yeah.
So typically what happens in this case is something went wrong during the trial. And it could be anything from a completely innocent mistake or error by an investigator to actual malicious conduct by the state. But the point is that in these cases, typically something goes wrong during the trial, and then there's an appellate process. And during that appellate process, the Innocence Project gets involved and gets someone out of trouble, essentially. But what we're talking about here are things that happen before a trial even happens. So a person is held on dangerousness, they don't get the right to a jury trial, and they're simply held there for, again, even today, even after COVID's kind of blown over, people are still getting held for 120, 180 days.
Can you explain to me, or do you know why the courts did not use Zoom to carry on the necessities of the legal system?
Well, to a large degree, they did. I'm on Zoom all the time with
In court?
with the Berkshire Superior Court, all the time, and I have been throughout the period of the trial. The issue is not whether the court embraced the technology. It did. The court absolutely did embrace the technology, but it could only embrace the technology for issues where you didn't need a lot of people in a room. Right? So if we would have a hearing with just a preliminary pretrial hearing, let's say, regarding some evidentiary issue, it would be myself, the prosecutor, the clerk, and the judge over a Zoom hearing. And the press had access, if they wanted it, to Zoom in. But the question becomes, what happens when you need a jury trial? Now, in the Superior Court, typically, to pick a jury of 12 people plus one alternate juror, typically, the amount of people that have to walk in off the street that have to be examined for their suitability in the jury is typically somewhere between 35 and 55 people. That's usually how many people have to walk into court. So if you can imagine...
For criminal or civil?
Let me speak to criminal only, because that's where my field of expertise is.
Forte, yep.
But civil trials also, need juries. And so the issue becomes this. How do you put 55 people in a room together in the middle of COVID? Right? I mean, you just can't, right? No. And so
too dangerous.
And so there's the issue. But even if you could do that, you'd be in a situation where after you had seated the jury, you would have 13 people sitting shoulder to shoulder. You've seen what a jury looks like, and so the point is, it would have been unsafe for everyone involved. And plus, there's additional issues too, because every time that a person is transported from the House of Corrections to court to stand trial, they become exposed to the outside world, which creates a risk to the staff of the House of Corrections later on, because if it were to spread in a contained environment like that, it would be a disaster. So there were just a lot of security type issues, security and health type issues that prevented the courts from doing trials. Again, to be fair to the court, we did everything we possibly could pre-trial. But when it came to the process of actually picking a jury and going to trial, we just couldn't do it.
Mm-hmm. I know one of your areas that I'm also very interested in is pro bono work. Mm-hmm. Will you discuss that so our audience understands that? And also, you are part of, or you discussed with me, an advocate program, the Bar Advocate Committee.
Yep.
Would you explain that and tell what that is? I think this is just stellar work that you are doing with that.
So, so these are two separate things. First of all, the question of pro bono work. Pro bono work is essentially it's legal charity work. You know, we as attorneys were given a great deal of privilege in terms of our education and our access to the courts that a lot of normal folks don't have. And so, you know, there are many situations where a person simply can't afford an attorney, that an attorney will, you know, will take the time to represent people. And practically every lawyer I know has some kind of pro bono practice. I've participated in a number of things. I've helped people involved in both the criminal and civil legal systems, you know, resolve trouble when they really needed the help. I helped a number of protesters at the Otis State Forest who were trying to block the expansion of a pipeline. That was an issue.
Which is where I met you. It was very wonderful to meet you there, protesting that.
You know, that was an issue that was very near and dear to my heart, because I felt like the bottom line is I think that we have limited natural resources, and all the folks that were involved with this protest, what I loved about that protest is that they were committed to nonviolent change.
Yes.
You know, and so the funny thing about representing all these folks was that we would come to court and the protesters were nothing but polite to the police, and the police were nothing but polite to the protesters.
Yes.
It was a wonderful experience. Now over 100 people got charged with various misdemeanor offenses, typically trespassing. But we worked it out with the DA's office in the long run. This was Paul Cacaviello's DA's office at the time. We worked it out that essentially, at the end of the day, nobody was convicted.
I just have to tell this little side story, because when we were at Otis Forest, there's Frances Crowe in her late 90s in a wheelchair, and the police and the sheriff's department were so wonderful to us. And I said, "You're not going to take her to jail. I go, can you talk to her, Rachel?" And I said, "Oh, she won't say no." But I followed. I let people follow me so they knew where the jail was. Everybody. "Are you all right, ma'am?" Everybody was absolutely as courteous and as respectful as possible. And Frances was quite a character.
Listen, she's
a great,
an incredible woman.
Nonviolent fighter. She called herself a resistor.
You know, this is really goes to the core of who we are as Americans. You know, we have a voice, and we use that voice. And oftentimes, particularly, I think maybe over the course of the last 10 years or so, we've seen so many protests that go wrong, you know, where they turn violent or really nasty, and there's acrimony between the police and the protesters. To be involved in a protest where the police work hand in hand with the protesters to make sure that everyone gets through it safe, everyone gets their voice heard respectfully, it's a beautiful thing. It really was an incredible experience for me, and I know that the protesters, you know, they're people that are very true to their message. They truly believe in saving the environment. And here in the Berkshires, it's a large part of what we have. Not just in terms of global warming and you know, the issues that we all care about, but also, you know, I have some friends visiting the Berkshires right now. And why do people visit the Berkshires? It's because it's beautiful.
I think a lot of people in the Berkshires don't realize how blessed they are. I've lived in the inner cities for 30 years, and it was stunning change for me to come back.
And you can't, once that's gone, that's gone.
Yeah,
You know, that's
yeah.
that's it. We've lost it.
I'm very concerned about the lack of
Yep.
taking it seriously worldwide
Yep.
and in the United States. Very concerned. We are actually coming close to the
Yep.
end, but I
Wow.
do want you to
Yep.
talk about, you must come back. I do
Sure.
want you to talk about the Bar Advocate Committee, what
Yep.
that is.
So the Bar Advocate Program of Berkshire County provides court-appointed counsel to folks who are essentially under the poverty line. So if you cannot afford an attorney, the court provides an attorney to you, and we, the bar advocates, we work for an organization called the Committee for Public Counsel Services. We worked hand in hand with them, and what we are is we are private attorneys. So I'm an attorney in private practice, but I will assist the court with taking some cases like that. And there's a number of us that do this work, and essentially it's a way to make sure that the public gets access to legal representation when they're charged with a crime. And so that's what the Bar Advocate Committee does.
How does someone go about, is there like a telephone number, a place you call that you can find it out?
So typically,
go online?
First of all, you can look up the Bar Advocates online. Just Google it, Berkshire Bar Advocates. But typically, our relationship with a client begins when we get appointed in court. So if you get charged with a crime, you get a court-appointed attorney, the Bar Advocates is going to take that case, either us or the Committee for Public
These are
Counsel
criminal
Services.
cases.
Yes.
Where this is appropriate.
Yep.
Wow. I'm just delighted that you've come here. This is obviously an ongoing conversation.
Yep.
There is just so much to discuss, but I feel quite sure we've enlightened our audience
I hope
today
so.
on some things and how important the rule of law is in representation. It's just terrific. Please come back. And
I would
thank
love
you.
to. I would
Thank
love
you
to, and thank you for having me.
Oh, thank you so very much for being my guest. And if each one of us picked up one problem and solved it, imagine the incredible view we would all have of solutions rising. Thank you, Attorney Joseph Zlatnik, for being our guest today, and please come back.
I would love to, Rachel. Thank you very much.
You are so
Have
welcome.
a great day.
You too.